today. I greeted you because you were leading last time.
Good morning, Chair.
Yes.
That is correct. I was leading last time,
Yes.
but for today's purposes, counsel, Advocate Mohomani, she's the one who's going to be leading.
Thank you.
Morning, Chair. Morning, Co-Commissioners.
Good morning.
It's Mohomani.
Yes, Commissioner, it's Mohomani.
Please spell it for me. I just want to.
Surname, Chair, it's M-O.
Just
H-O.
Thank you. Are you ready, Ms. Mohomani?
Yes, Chair, we are ready to proceed.
Yes.
Chair, prior to starting, I thought it would be prudent to inform the Commission. We spoke to Mr. Mogotsi. He said that he's delayed in traffic, but his GPS shows him that he'll be here in the next 15 or 18 minutes. I'm uncertain how the Commissioners would like us to deal with the matter. Do we proceed in absentia or do we wait for him to arrive? I seek the chairperson.
This, to my mind, this is very much akin to a motion matter in court. You don't need the litigant in such a matter. So let's start.
Thank you, Chair. Co-Commissioners, this is an application that is being brought by Mr. Opa Brown Mogotsi for the recusal of Matthew Chaskalson SC, who is the chief evidence leader in the proceedings where Mr. Mogotsi is witness. Now, Chair, what the relief that the applicant seeks is that Advocate Chaskalson be recused from the matter and an alternative evidence leader be appointed to cross-examine Mr. Mogotsi. The basis of the application rests on the possibility of biasness or impartiality. And this, Chair, stems from
Actual bias or actual bias alternatively perceived?
perceived bias, Chair.
Not actual, but perceived.
Perceived bias.
Thank you.
yes, Chair. And the reason for this perceived bias is as a result of events that took place before the Commission on the 9th of March and the 10th of March. Mr. Carrim Suleiman came in to bear testimony before the Commission. Now, during the said days when Mr. Suleiman was giving testimony, there was communication between the evidence leader and Mr. Mogotsi, who's the applicant for the recusal. That communication comes in the form of WhatsApps.
I think there is an antecedent question, a legal question, because how we grapple with the events that you referred to depends on what the law is. Because you must first know what the law is, and then you apply the law to what you've referred to as the events, which effectively are facts or factual issues. In your application, you rely on SARFU and other cases. Those cases relate to situations that involve decision makers in whatever form those may manifest. The respondents have taken the point that those cases are irrelevant to a situation like the present, where a decision maker is not involved. And the point made is that the chief evidence leader is not a decision maker. So what law are you relying on? Because the point is correct that the cases that you've referred to in your application relate to decision makers. So are you continuing to rely on those cases? If so, on what basis would they be applicable here?
Chair, I would be inclined to concede that the cases or the case law that was used by the applicant is that of the decision makers and not the parties who partake in the proceedings. But then from that, Chair, I will also submit to the Commission that case law has been brought to the attention of the Commission in the form of an answering affidavit by the respondent. And the cases that are therein mentioned do make provisions for instances where prosecutors and, with this case, an evidence leader may be recused from certain proceedings.
Can you state the principles insofar as you see them, and for us to have an idea of the case you want to make out?
Chair, there's between Mr. Mogotsi and the evidence leader, and it's issues that the evidence leader should be answering and not the attorney. Commissioners, there has been an explanation that was proffered in the replying affidavit regarding these deleted telephone calls or emojis. Now,
I'm sorry, please don't forget the point
where I was, yes, Chair.
you were about to make. In the context of hearing the testimony of a witness, and in fact even beyond that, the applicable prescripts say that the rules of evidence that apply, for example, in courts of law, do not apply to commissions of inquiry. Commissions of inquiry may receive evidence of variety of forms which would ordinarily not be admissible in courts of law. But as I say, that's in the context, or that's provided for in the context of the commission receiving evidence towards the investigation that it was set up for. That's the context. Would you say that those rules with regard to the admissibility, acceptance of evidence would not apply to an interlocutory process like the one we have before us now? You would have that permissive manner of receiving evidence in the context of receiving evidence towards the investigation, but have a very restrictive process when it comes to interlocutory matters that relate to the Commission's investigative process. I'm asking that in the context of the point in limine that you are raising. Wouldn't there be an anomaly if that were to be the case?
Chair, in the normal route, that would be an issue to raise. However, in light of what you are saying to me or what you are putting to me, I'll submit that in a quasi-judicial tribunal like of this nature, then I cannot take that point in limine any further. If that is then the status quo, I will have to leave that point in limine and not argue it any further.
Thank you. I did not want us to reach a situation where, for example, we decide your point in limine along the lines of what I've raised with you without offering you an opportunity to respond. Well, I have offered you that opportunity and you have responded. You may go back to the point I asked you not to forget.
Oh, yes, Chair, thank you. Chair, I was making a submission with regards to the deletion or the alleged fraudulent deletion of conversations in the WhatsApp records. And I was further saying that Mr. Mogotsi did respond to those allegations that were put forth by the evidence leader. And at paragraph 41, which will be at page 267 of the replying affidavit.
Yes.
Mr. Mogotsi says that he admits that he deleted the message dated the 11th of March that was sent at 11:29 a.m. And the intention was not to mislead the commission, as at the time he had not even contemplated bringing the application here in. He further says in the next paragraph, the sole intention behind the deletion was to protect my conversation with the first respondent from third persons. The next paragraph, he says that he admits that he deleted the calls on the basis that at the time of taking the screenshots for purposes of this application, he did not find them relevant, and furthermore, he's further to allow me to take screenshots of the relevant facts. I therefore deleted them. I understand this, Chair, and I'm subject to correction to say that to allow me to take screenshots of the relevant facts, his headset doesn't allow him to take screenshots. I'm uncertain how to read this, and I seek the guidance of the commission.
No, just make your submissions.
I submit that.
There's no need for guidance from us on this.
I submit that, and subject to correction, that his handset did not allow him to take screenshots of the relevant facts. He therefore deleted them. The calls that have been deleted were unanswered and therefore hold no significance to the application.
Except, of course, that they may assist in the context of what I engaged you on right at the beginning. I will not repeat that. Please continue.
Chair,
the point I made about, based on the number of calls, who appears to have sought out whom in that context. Please continue.
Chair, what is common cause is that, yes, there was communication between Mr. Mogotsi and the evidence leader. And during those conversations, a discussion came in regarding Mr. Carrim. It's also common cause that during the conversation, there was an agreement or a request to bring certain evidence to rebut what was put on record regarding Mr. Mogotsi, to defend himself, and if the need arises, to throw Mr. Carrim under the bus. Now, Mr. Mogotsi's evidence is that the communication between himself and Mr. Carrim formed an impression that his cooperation in providing information against another witness was linked to his treatment in the proceedings. And this, Chair, will find at paragraph 7 of the replying affidavit. And he further says that whether intended or not, such perception undermines the appearance of impartiality. Now, it goes back, Chair, to whether or not a reasonable, objective and informed person would apprehend bias. Now, with what had transpired and with Mr. Mogotsi due to come back to the commission and testify, and him not being able to have provided any information that was helpful because the meetings never happened, he became fearful of appearances of impartiality, and that he would, upon his appearance, be treated unfairly.
Mama, is it not opportunistic to offer Mr. Chaskalson information on Mr. Carrim and then fail to deliver because Mr. Mogotsi turns out doesn't have that kind of information, and then say, I fear that Mr. Chaskalson will be biased against me because I did not give him that which I promised? Isn't there some opportunism there? You offer and then you fail to deliver, and then without more you say he's going to be biased against me. I mean, he hasn't referred us to anything in the chats which shows Mr. Chaskalson being upset with him or saying to him, you know, I'm going to get you for failing to deliver. There's none of that, other than that text which we have read in context, that it actually doesn't quite convey what you were saying, where it says, don't mess with me, don't mess me around or something like that. I don't understand how that an offer made which couldn't be fulfilled without more creates a reasonable, remember the test is reasonable apprehension of bias, how that would create a reasonable apprehension of bias that after this he's not going to treat me fairly.
In response, Commissioner, what we had considered is that Mr. Mogotsi is the one who called the evidence leader. That is not in dispute. However, what was contained in the phone calls, and I had said previously, I do not know, and neither does anybody know what was discussed in these telephone calls.
But then in that case, how can the commission say the apprehension is reasonable if we don't know what was discussed in those calls? You're saying that we don't know, therefore we don't have the content of those telephone calls according to you. So we lack the necessary facts on the basis of which the commission can make the determination that the apprehension is reasonable, because eventually that's what we must find. We must find that the apprehension is reasonable.
Commissioner, firstly, I'll invite the Commission to make a finding through what is contained in the papers. Now, what seems to be a challenge is that with regards to the telephone calls, there's a dispute of fact. One says, I said, the other says, I said. Hence, I keep on repeating that I do not know what was contained in the telephone conversation. And Commissioner, you would also not be in a position to know what was discussed in those telephone conversations. And unfortunately for me, there is no recorded conversation of what would